Good afternoon, sir. My topic for presentation is writ of certiorari and prohibition and its scope and extent. Moving to the introduction, a writ can be defined as a written formal order which is issued by the court. The formal order can be in the form of a warrant, a direction, command, order, etc. Writ can be issued by High Court under Article 226 of Indian Constitution and by Supreme Court under Article 32 of Indian Constitution. Indian Constitution adopted the concept of this prerogative writ from English common law. The High Court and Supreme Court this can issue these writs not only for the purpose of enforcement of fundamental right but also to control the administrative and quasi-administrative action. The High Court and Supreme Court exercise judicial review through the writ of certiorari, prohibition, quo warranto, mandamus, and habeas corpus, and also through the exercise of power under Article 136 and 227 of Indian Constitution. Now moving to the main area of presentation, that is writ of certiorari. Writ of certiorari can be defined as a judicial order which is issued by the Supreme Court or High Court to an inferior court or to an authority which exercises judicial, quasi-judicial or administrative function for the purpose of transmitting to the court the record of proceedings which is pending with them for the purpose of scrutiny and to decide the legality and the validity of the order which is passed by them. And through this writ of certiorari, the court can quash or declare invalid a decision which is taken by the concerned authority. With the passage of time, the scope of writ of certiorari has undergone wide change. That is, the constituency within which the certiorari can be operative has been tremendously enlarged because of its corrective nature, which means that the writ of certiorari now can be issued against constitutional body, including legislature, executive, and judiciary and their officers, and against the statutory body, including corporations and also other authorities which is constituted under any statute, and non-statutory bodies including companies, cooperative societies, private bodies, and persons. The requirement that certiorari can be issued only when the action is judicial or quasi-judicial is no more valid. Next is ground under which the issue of writ of certiorari can be made, and there are nearly 6 grounds under which the writ of certiorari can be issued. These are lack of jurisdiction, excess of jurisdiction, abuse of jurisdiction, violation of the principle of natural justice, error of law apparent on the face of record, and also fraud. First, on lack of jurisdiction. Lack of jurisdiction refers to a situation where the authority has not at all have any jurisdiction, and it can arise in following situation, that is, when an authority is improperly constituted, if the authority commits an error in its decision on a jurisdictional fact and thereby assumes a jurisdiction which doesn't actually belong to that authority, if authority is incompetent to take action in respect of a particular subject matter or locality or a party, and if the law which gives the jurisdiction to an authority itself is unconstitutional, if the preliminary essentials have been disregarded. The lack of jurisdiction is explained in the case of Buddh Prakash Prakash versus sales tax officer. In this case, the lack of jurisdiction where the subject matter was outside the scope. Here, the sales tax officer exercising the power under the UP Sales Tax Act imposed tax on forward contracts irrespective of the place where the delivery took place. The court issued the writ of certiorari on the ground that the subject matter was outside the jurisdiction of the authority. Second condition under which the writ of certiorari can be issued is excess of jurisdiction. Excess of jurisdiction refers to a case where authority has jurisdiction but it exceeds the permitted level, and it is well explained in the case of J.K. Chowdhury versus Datta Gupta. In this case, the governing body of a college which is affiliated to the Gandhi University dismissed this principal on the ground of his misconduct. The executive authority of the Gandhi University, after hearing the representations, ordered reinstatement. The court issued certiorari to quash the decision on the ground of the excess of jurisdiction because the jurisdiction of the university under section 21 clause 9 of the Gandhi University Act was confined to the teachers and did not extend to the case where the person holds the office of a principal. The third condition under which the writ of certiorari can be issued is abuse of jurisdiction. That is, certiorari will also lie to quash the action of an authority where the authority has jurisdiction but abused the jurisdiction. An authority is deemed to have abused the jurisdiction when it exercises the power for an improper purpose, for an extraneous consideration, or in bad faith, or leaves out a relevant consideration. Fourth condition under which the writ of certiorari can be issued is the violation of the principle of natural justice. That is, to set aside any decision given in the violation of principle of natural justice, writ of certiorari can be issued. There are two principles of natural justice which is recognized by law. These are rule against bias and rule of odi alteram partem. Rule of odi altrum partem, which means here the other side, that is, every judicial or quasi-judicial body must give equal and reasonable opportunity to the party to make their representation. In other words, it can be said that the parties whose civil rights are affected in any proceedings before the court must have a reasonable notice of the case he has to meet and the opportunity of stating his case. And rule against bias and the principle of natural justice is well explained in the case of Circe Municipality versus Cecilia Combe Francis Tellis. In this case, a hospital worker was dismissed for alleged negligence, which resulted in the death of a patient in the mortuary in the maternity ward of the municipal hospital without providing him a hearing. The court quashed the decision on the ground of the violation of the principle of natural justice. Next is rule against bias, and rule against bias can include personal bias, pecuniary bias, subject matter bias, departmental bias, etc. Bias and interest is the second principle of natural justice, which states that no one should be a judge in its own case. Elaborating the principle, which means that the judge deciding a case does not may have any interest in the case in which he providing his decision, because it is a human tendency that a person can be wrong in his own eyes. Therefore, biasness will emanate and aim for fair justice to all could not be made. And two principles for governing this doctrine of bias and interest is no one should be a judge in its own case, and justice should be manifestly and undoubtedly seen to be done. Another condition under which the writ of certiorari can be issued is error of law apparent on the face of record. It is well settled that the certiorari will be issued to quash the decision though which is made within the jurisdiction revealed on the face of record and error of law. The record for this purpose shall include document in which the determination is recorded, document which indicate the proceedings and pleadings. The term error apparent on the face of record cannot be defined with clarity. Whether or not an error is an error of law, an error which is apparent on the face of record must always depend upon the facts and circumstances of each case and upon the nature and the scope of legal provisions which is alleged to have been misconstrued or contravened. Error apparent on the face of record shall include not a mere error but a manifest error based on the clear ignorance of or disregard of law, or on a wrong proposition of law, or on a clear inconsistency between the facts of the law and the decision. In the case of Sankram Singh versus Election Tribunal, the Election Tribunal construed Section 9 of CPC to mean that if a person failed to appear before it without good cause, he can be debarred from taking part in the subsequent proceeding. The court quashed the decision of the tribunal on the ground of the error of law on the face of record. Another condition under which the writ of certiorari can be issued is fraud. If the decision of the agency has been obtained by fraud, or the fraud operate to take away the jurisdiction or bestows jurisdiction, or result in the denial of justice, the decision may be quashed by issuing certiorari. Next, writ of certiorari may not be issued against an individual, a company, a private authority, an association or tribunal having no judicial or quasi-judicial powers. Also, it can't be issued for making declaration that an act or statute is ultra-vires or unconstitutional. And next, moving to the writ of prohibition. Writ of prohibition is an it is old as common law. Initially, it was used to limit the jurisdiction of ecclesiastical by restraining them from acting without or in excess of jurisdiction, and later it is used by the common law. It is an extraordinary writ of preventive nature. It prevents the courts, tribunals, quasi-judicial bodies, and other officers from exercising their power and beyond their jurisdiction, or exercising those powers which are not vested on them. The purpose of this writ of prohibition is to issue or to bar them from doing something which they are not about to do. In the case of S. Govinda Menon versus Union of India, in this case, the Supreme Court has explained the jurisdiction of the court for the grant of writ of prohibition. It says that the power to issue the writ of prohibition is primarily supervisory, and the main object for behind the writ of prohibition is to refrain inferior court or the tribunal from exceeding their jurisdictional limits. It is well settled law derived from the decided cases that a writ of prohibition lies not only in the case of excess of jurisdiction or for the abuse of judicial power, but writ lies also in the case where the action are taken in the contravention to the rule of natural justice. A writ of prohibition is a writ of right and not a writ of course, and it is of preventive nature rather than corrective nature. Then against whom the writ of prohibition can be issued? Writ of prohibition is much in common with certiorari in its scope and as well as in the rules of its governance. Therefore, both these writs lie against a judicial and quasi-judicial body and not against any executive authorities. Ground for the issue of writ of prohibition. that is absence or excess of jurisdiction, where there is an absence of jurisdiction or total lack of jurisdiction, violation of the principle of natural justice. In the case where the principle of natural justice have not been observed, or if observed there is a violation of those principles, unconstitutionality of the statute, infringement of fundamental right, error of law apparent on face of record. Now moving to the conclusion. It is a fact which cannot be denied that due to the intensive form of government at present, there is a tremendous increase in the function of administration. Therefore, these new founded powers have to be properly exercised. Otherwise, it can lead to a totalitarian state. Against this backdrop, the prime function of the judicial review is to check the abuse of administrative powers and to enforce accountability on the operators of these administrative powers. The prerogative power writ jurisdiction, which is conferred by the Constitution for judicial review of administrative action, is undoubtedly discretionary and it unbounded in its limits. The discretion, however, should be exercised on sound legal principle. In this respect, it is important to emphasize that the absence of arbitrary power is the first essential of the rule of law upon which the whole system of constitution is based. Thank you.